do, Ms. Monroe, in determining the appropriate sentence in this case, this court must consider a number of factors, including the seriousness of the offense that you've committed, your criminal history, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what is and what will be stated on the record today. I'm going to give your attorney the opportunity to address the court first on your behalf. Once your attorney has addressed the court on your behalf, you will also have the opportunity to address the court if you wish, followed by the prosecution, and if there are any victims here who have come to address the court, they will be invited to do so as well. So with that said, Mr. Zaney, please proceed.
Thank you. Your Honor, I just asked the court to recognize the filing of our sentencing memorandum in this case.
Yes, it has been received.
Thank you. And I know the court has reviewed that sentencing memorandum, as the court commonly does. And I think what is often the challenge is to find the right words for every situation when presenting a client to the court. And I think we were best able to do that in the sentencing memorandum. I believe the sentencing memorandum, which we're going to ask the court to incorporate into its decision here today by virtue of our position, is one that takes into account all of the sentencing factors that the court should consider. I would remind the court, and I think you noted this was a no contest plea, which, as the court is aware, affects the, there's purposes for that and affects my client's ability to freely speak. And I think, though, we've captured the essence of remorse and recognition of the offense in the sentencing memorandum. At least that was our attempt. And I think we did a diligent job showing the court that. I think the sentencing memorandum, again, addresses all the sentencing factors that the court needs to take into account. And we're renewing our request for the court to accept the agreement between the prosecutor and defense in this case and sentence accordingly. And we would just rest on the fact that the information in that report has been reviewed by Ms. Monroe and is something that I think can ultimately be the best picture you can understand Ms. Monroe's situation from the time that this incident occurred to coming before the court today. So without any additional magical words, Your Honor, I think the court's left with the consideration of sentencing her to the Killebrew agreement or not. Thank you.
Thank you. And Ms. Monroe, did you wish to address the court at all today?
No, Your Honor.
Thank you. All right. I would ask then that defense, Ms. Monroe, Mr. Zaney, Mr. Dobies be seated. I will call the prosecution up and ask if there are any individuals, any victims here who would like to address the court before we sentence.
Yes, Your Honor. At this point, we have 10 people.
Thank you.
Over the past year and a half, my staff at my office and myself have had the honor of meeting and getting to know all the members of the family that were struck that day. And we've had to have the most impossible decisions with them about initial charges, if we should run a preliminary examination and ask Judge Clarizio at the time to send the case up on murder, if we should have a trial, consulting with them on what kind of offer, if any, should be extended to the defendant. And I want this court to know, even though today technically is about the sentencing of the defendant, that that family over there has acted with nothing but grace and love and are truly an example of how families should treat each other when the unthinkable happens. I wish I'd never met these people under these circumstances. I really wish it had been other circumstances, because there are people there that are such good humans. And it really makes you wonder, and I've dealt with a lot of crime, a lot of horrific things that have happened to people in their lives. Why, when something like this happens, does it happen to people like that? And I thought of all the people, and I was taking note when they were speaking, of all the people there that day. A first grade teacher, a mom, a 3-year-old, a 6-year-old, a 2-year-old, a dad, a grandma, an aunt, a wife, a newlywed, an EMT firefighter, a young doctor, a military veteran, and people who loved each other. I was not there on May 18th, 2024, but I will tell you, I know you've just heard a lot of statements from a lot of people who were there. And I want them to know that there was another side that day, because when I first got the call as the on-call prosecutor that weekend, it was from a seasoned member of the Clinton County Sheriff's Office to tell me that this had just happened in Clinton County. And I have never, in 25 years of practicing law, 15 years of being a prosecutor, had an officer call me, and when they were telling me what happened, break down during that call. And the reason he broke down was because of the kids, the children that were there and saw what happened. And right in that moment, even though I didn't fully understand the magnitude of what was happening in our county, I knew that this was something so horrific that it had rattled someone with that seniority. The victims, their family, their friends, their supporters, their colleagues have shared so much with this court about who John and Dan were, about how their lives have been impacted. And there's some people who question the agreement for the 30-year minimum on this. And I know that was an impossible decision for the family of Dan and John to make. And I want to be clear that that is the minimum sentence. That is the Killebrew agreement. That is what we stand by today, that she not be eligible for parole for 30 years. And if, I hope she reflects on this, she understands that this isn't something that happened to her. This isn't something bad luck that happened to Ashley Monroe that day. That's not fate, that's not, none of that. This happened to them, not her. She made multiple choices that day, and although the drinking and driving has been mentioned multiple times, and that's certainly a large part of it here, because we know from her blood results that she was a .195, keep in mind we're not here on operating while intoxicated causing death. The primary plea here, which carries the maximum sentence that she can get today, is murder in the second degree. And that is because choices were made here where this was foreseeable. This wasn't just operating while intoxicated causing death. This is drinking to a .195, along with the choice of being on medications that say not to drink at all. And even though they say not to drink at all, she didn't have 1 drink or 2 drinks. She drank to .195. It is the choice of driving in that car, getting behind the wheel, continuing to drive for about 2 miles down Wacusta Road, going off the road to the right, going into opposing traffic on the left in no passing zones over hilly areas, doing that multiple times and not making the right choice at any time to pull over her car and stop. I had the opportunity to go to the scene where all of our survivors and our victims were hit. I walked that scene, and what struck me the most looking at what's there is this is clearly a park area. This happened in daylight. This happened in a space where a driver would reasonably be able to see that going through that section of the roadway, they should be exercising reasonable caution based on what is on that road, what is around it. There was plenty of space to see the number of people that were there, dressed in bright colors, standing there in the middle of the day. We have evidence from Monica Fabis that when she was coming towards the guardrail where this family stood, she wasn't even looking out her windshield. She was looking straight down. What was she doing? Some people have guessed maybe on a phone. Some people have guessed who knows what. But she wasn't looking at the road. So with medications, alcohol, not looking at the road, swerving all over the road and not making a choice out of the multiple times she did that to pull over, she made choices. As one of the victims pointed out, multiple choices. And those choices took choices away from these good people back here. This isn't something that happened to her. It happened to them. And I have heard things about, of course, she doesn't have any convictions on her record for prior criminal acts. And I get that. I do. And I know the court has to consider that. But there is a difference here between intent and impact. And when the court looks at the snow factors, part of what the sentence has to be is deterrence. I don't have a time machine, I know this court certainly doesn't, to turn it back and bring Dan and John back, to bring back Jessica's leg, to bring back all the trauma they've been through. But the court can say to the community, this will not be tolerated because the sheer damage that it does to the citizens who live here, who visit here, who are here, there has to be a message sent to others in the community that when you make choices like the defendant did, the penalty is going to be severe. The consequences are going to be severe. 30 years probably isn't enough. It's not. But when you have these impossible conversations about going to trial with a jury and seeing what a jury does, it was the decision that was right at the time. I also want to say, after meeting this amazing family, that there may be things that they do not know from that day about miracles And I do believe that in some situations when we have a case like this, we have to have accident reconstructionists who put together what happened and try to tell the prosecution or the court or the defense attorneys what exactly happened. And there were some miracles this day. One miracle I want to say is there was a person on scene who was one of the first people to stop. His name was Jeff Hinkle. He hasn't testified in anything so far. He's a member of the community. He was an off-duty EMT, and he stopped, and law enforcement told me that but for Mr. Hinkle, this would have been a worse situation than it was. Mr. Hinkle got out of his car, stopped, and immediately took control of the scene, even coming up to the first officer who arrived there and was able to tell him who needed treatment immediately and what was going on. The fact that he was the first person who just happened to stop that day is simply amazing. Second, defendant left the scene. We know from Gabe, who is the young man, you can't see him on our screen, but he's the young man in the group picture far to the left, that when she was driving away after hitting his family member, she had her hand over her mouth. She knew that she had just hit many people, and she kept going. She left them there, no better than trash, no better than roadkill, no better than a piece of litter she threw out her window. She put her own well-being, her own self-preservation among her fellow human beings who she just hurt. Perhaps the only way she was actually apprehended, and we know who did this, and we're able to be here today, is because of some miracle of the universe, 2 deputies from the Clinton County Sheriff's Office who were coming to the scene and were in the right place at the right time, taking a route they normally actually wouldn't have taken but for the fact that one officer was training another, passed her vehicle on a 2-lane highway, going, I think they said about 100 miles per hour to try to get to the scene, and one of them, out of the corner of their eye, saw the far side of her windshield flash in the light and realized it was damaged. They immediately turned on that car and were able to stop her. And even after she was still going down that road when the deputies found her, dropping pieces of her car along the road, driving off the road still, they were able to identify her and connect her to this horrible event that just happened. The fact that they were where they were off their route is amazing. Another miracle. A lot of times, unfortunately, with these kind of incidents, we don't have witnesses who are not involved who saw what happened. I want the court to be aware that there were people, even though defendant didn't stop, there were people minding their own business that day at the park or near the park that came and did everything they could. Several people who were there, I think one was kayaking, had just finished kayaking, stopped and gave statements to police. They came and testified at the preliminary hearing. These people who also, based on the horrific nature of what they witnessed because they saw the impact, are also going through their own counseling. They didn't walk away. In fact, the humanity of Miss Temez, she saw Jennifer Evans, who was our first speaker, get launched. Jennifer went the farthest out of all the victims. She was sent away from the group. And her first thought was to get to Jennifer because she was worried that no one else, that the first responders wouldn't know that she was over there that far. And when she testified and when I spoke to her, she said exactly what Jennifer said. The first thing when Jennifer became conscious was she asked about her little girls, who are those 2 little girls in the bottom right corner, who by some miracle are alive. I don't think Jennifer remembers this because I think she was in shock, but Natalia was there encouraging her to stay awake during that time while everyone else was with the main group. I also want to thank Leanne Miller, who testified at the prelim, who was in the car behind the defendant, who testified about what she observed. She also stopped her car. Miss Miller, the first person that Miss Miller saw was little Ivan, who you can't see on here, but in the group picture, he is the little boy being held by Jessica. He was the only family member who was still in the road. Everyone else got thrown over the guardrail. Ivan was still on the side of the road by himself. She went to him and comforted him, a 3-year-old face down, offering him water, trying to put something under his head, take care of him. His dad had just been killed, unbeknownst to her, and his mom didn't even know if she was going to survive. The 2 biggest miracles of that day. Number 1, is that Jessica Harris survived. When this case first came out, and I was evaluating the law regarding second-degree murder for John and Dan, there was a time when the people were thinking this may be 3 murder counts. And whatever strength of will is in that woman brought her through the immense pain, suffering, and injuries to survive for those children so that they didn't lose both parents that day. And then finally, although I didn't know John or Dan, when I listened to the statements of their loved ones, and when I read, I know we gave you multiple other letters, Your Honor, from other people who loved, knew, and cared about these 2 men. The fact that statistically, based on the people that were in that group, most of them were children. The fact that we are not here on murder charges for children is simply astounding from a statistical standpoint. And maybe it's a miracle, but I also know after listening to what these 2 men are, that if 2 people had to die that day, it wasn't going to be a kid, and it wasn't going to be who they loved. And so when I hear their loved ones talk about them being protectors and caring about other people, I can almost guarantee you, without knowing them, that they would have been the 2 first people to sacrifice themselves for the rest of their family. And so it's not lost on me that the 2 people that were lost out of this incident are these 2 men, because they would have given that for them. I want to thank all the police jurisdictions because as I prepared this case and talked to the officers who, as John's department pointed out, they worked very hard on this case. One officer told me, in fact, that he will never forget this case because as soon as the call came out that multiple people were injured, that it was a fatality, and that there were a lot of kids involved, that the radio did not stop beeping with all the departments from all the areas who started coming lights and sirens to help. And he said, I will never forget that. You couldn't get through. There wasn't a department in the area that was not on their way to provide help for this family. All in all, it doesn't change that John and Dan are gone. It doesn't change the injuries and the sentence that this family has gotten, that they were sentenced to on May 18th. But we ask that you send the message to the community that defendant be held responsible for her choices that day, because this was murder, that she be responsible for the number of lives she's impacted that will carry on, as someone pointed out, generationally for this side and this side. That even though today might be the last day of the court proceedings before you, it's not the last day for this family. And we ask that, Your Honor, you follow the Killebrew Agreement, that she be sentenced to a minimum of 30 years in the Michigan Department of Corrections, with the top of that number to be set by Your Honor, but we ask that it be no less than 60 years.
Ms. Martinez, I have a question
Sure.
for you. I just want to make sure that my math is correct, because I know this was a carefully crafted plea agreement between the prosecution and the defense. So as to and I'm looking at the homicide murder second degree guidelines, I read 225 months to 375 months to life. So my calculations indicate that would be on the lowest end 18 years and approximately 18 and 3/4 years.
Correct.
So 18 years and about 9 months. And then on the higher end of the minimum guidelines, that would be 31.
Correct.
Okay, so that would be, so the 30-year would be within the properly
Correct.
scored guidelines, and I don't think there was any dispute.
Correct.
All right, and that was, okay, I understand. Thank you very much.
Thank you.
Monroe, the criteria and the reasons for the sentence is the nature and the gravity of this offense, the punishment or discipline to you that is appropriate, the potential for your rehabilitation or reformation, the the protection of society and deterrence against you or someone else committing this offense again. First of all, I would like to thank all of the individuals from the family who spoke today, everyone, and I'll just briefly recap what each person said. Ms. Evans testified about the fear that she had when she realized she had been involved in this accident for herself, for her daughters. Ms. Pak, who bravely came up and spoke about, again, her fears with this terrible incident. Captain Tiefel, who spoke on behalf of the firefighters union, talking about losing a brother that day in John, and he made a statement that was particularly poignant to this court. He said, this is from the captain, that you, Ms. Monroe, took away someone who would have moved heaven and earth to help people, and that was his brother, his firefighter brother, John, who worked as a paramedic, and as we've heard his wife and other people talk about, really seemed to connect with the most vulnerable people in society and really fight on their behalf to make sure that those people were properly cared for medically when they themselves were having their own issues. And Ms. Monroe, it sounds as if had the situation been different, and he would have cared for you too in that incident. We heard from Dr. Blatz, the widow of John, who, again, she talked about how her husband would sit and talk with patients that he dealt with as a paramedic, who offered no judgment to those people, who even those people who were constantly slipping in and out of addiction, needing the services of emergency medical personnel, and yet he would still tend to those individuals, as was his obligation and his job, and frankly, as Dr. Glatz indicated, his desire as a paramedic professional to help the community in the manner he did. We heard from Mrs. Esch, John's mom, who talked about the kindness of her son and how he cared for others, and that was exemplified in everyone's statements today about John and Dan, and how again, this family has lost such a great deal in losing these two men, and having other members of the family, including the youngest members, be injured, and what it sounds like facing a long and painful road to recovery. We heard from Ms. Fabice, who talked about her 2-year-old who had to endure and is apparently still going through the symptoms of PTSD, who had to seek out counseling, who the family has had some challenges with depression, and feeling like they themselves were responsible for this. Since the day that this happened, they were gathered to say goodbye to their family, their small family, who was taking another job overseas. And we heard from Mr. Esch, from John's brother, who really eloquently said, in addressing you, Ms. Monroe, what you're getting today is nothing like what our relatives have been going through for the past 515 days. So in other words, the sentence today, and I think other family members said this, this family is going to have to live with the memories of this terrible, tragic day for the rest of their lives, whether it's from their own memories of the incident, of the crash, of themselves, their family being injured and killed. A number of these family members have talked about reliving those moments in their lives and not being able to see a day where they don't either experience the physical pain or the mental pain of reliving those moments. Mr. Esch also talked about the fact that, again, the powerlessness of himself not being able to help some of the victims, while his wife, on the other hand, was performing CPR in a failed attempt to revive her brother-in-law. And again, I think that it went without saying that this was one of the best days. This day started out as one of the best days in this family's lives. Family traveling from out of state, from out of the area to meet, to say goodbye for now to Monica and David, who would be moving overseas, and their young daughter. enjoying time outside in the sun. And I do remember that this was a beautiful day outside. They were gathered in the park to enjoy, and I think someone said playing in the same playground that some of the family members played in when they were young children, and just enjoy each other's company. And it became the worst day of this family's life. We heard from Mrs. Harris, Dan's wife, who talked again about her own horrific injury, her own struggle for survival. We heard the prosecution say they originally thought this might be a 3-count homicide case, but through her own persistence and desire to carry forward, despite her husband's death, she survived. And we heard her struggles, and we heard Aurora's elocution about losing her dad. Well, we heard again statements from the family, and I'm just compiling them here. They will never be able to live normal lives again. And at the end, once all the family members had made their statement, the prosecution, Ms. Martinez, said she has wondered, why do things like this happen to people like this? People that were just out enjoying their time together. And really, I don't think there's a good answer to it. But what we do know is that Ms. Monroe, the defendant in this case, made what I understand to be the worst choice that she's ever made in her life. She made the choice to, while on prescription medication, consume a very large amount of alcohol to the point where her blood alcohol level was, as has been stated, 0.195, way more than anyone should be consuming, and then making the choice to step behind the wheel of a vehicle and then operate that vehicle and unfortunately crash into this family. And I agree with Ms. Martinez's sentiments that many miracles happened this day, and it is a miracle that we are not here mourning the losses of more of these family members. And it's funny because Ms. Martinez also talked about the fact that out of all of the family members that were present for this, again, what should have been a joyous gathering of these family members, the 2 people who perished, from what the family has stated about those 2 people, those are the 2 people that would have sprung into action to protect their kids, their nieces, their nephews, their wives, their mothers, and I guess, and I of course didn't know any of these people personally, but from the statements made, they displayed acts of heroism that, again, most likely reduced this incident from something that could have been even more tragic than it already is. So again, Ms. Monroe, I'm sure that if you could dial back this incident, and you didn't make a statement, and I don't hold that against you in any way, but I'm sure that if you could dial back this incident, you would. But unfortunately, you can't. And as all of these individuals, all of these family members said, they are going to have to deal with and the consequences and the ramifications of your actions for the rest of their lives. And I don't know that there's an explanation for what happened other than your choices that day. But I do know that something like this cannot happen again. Not here in this community, not here in Clinton County, not here in the state of Michigan, not ever. And so I do need to sentence you to a sentence that will not allow that to ever happen, not allow you to make these same choices again. I have reviewed the recommendation that's been provided to this court from the Michigan Department of Corrections. I believe it is in line with what the plea agreement is. And once again, I note that your sentencing guidelines permit me to sentence you from somewhere between 18 years to 31 years on the minimum, up to a longer term. And the recommendation provided to me by the Michigan Department of Corrections accounts for, yes, your criminal history, which you do not have any criminal history to speak of, but it also accounts for the horrific acts that occurred on this day on May 18th, 2024. And their recommendation for the homicide murder second degree charge is 30 years to 60 years with credit for 515 days served. And I intend to follow that recommendation. So as to the count 9 homicide murder second degree, I sentence you to the Michigan Department of Corrections for a period of 30 years to 60 years with credit for 515 days served. You must pay the court costs in the amount of $350. You must comply with DNA testing and pay a $60 fee as ordered. You must pay a $68 state cost. And this will be served concurrently with all of the other counts. This is count 1 through 8 of operating while intoxicated, causing serious injury. You will serve that sentence in the Michigan Department of Corrections for a period of 2 years to 5 years with credit for 515 days served. Those counts will be served concurrently with each other and concurrently with the second-degree homicide sentence that I just handed down. You will not have any verbal, written, electronic, or physical contact with any of the victims in this particular case, and all of the victims' names are listed in the pre-sentence investigation report. You will not have that direct contact or be within 500 feet of their residence, school, or place of employment. You must pay restitution in the amount of $73,128.44. $66,093.44 will be payable to Auto Club Insurance Association. $7,035 will be payable to the Michigan Department of Health and Human Services, and you must execute a wage assignment to pay restitution if you are employed and miss 2 regularly scheduled payments. You must pay $544 in state costs, comply with DNA testing, and pay attorney fees as ordered, and these fees will be determined. So I want to say one more thing as to your sentence with the Michigan Department of Corrections. This does not, again, not to minimize any of the family members who came in here and talked about the fact that for the rest of their lives they will relive the moments of this tragedy. But Ms. Monroe, I know you are going to a place, and I noticed in your pre-sentence investigation report, and I also noticed, but based on some of the certificates that you presented the court, that you do have, and I think it's obvious, a substance abuse issue that is the reason, one of the reasons why this terrible thing happened. I implore you to take advantage of any possible rehabilitation that might be offered to you within the correctional facility that you will be sent to, and you have a long time to serve, and I implore you to serve it wisely by making sure that this never happens again, and that no one else, and that this sentence deters anyone else from engaging in this type of reckless conduct. So with that said, you will be handed a document that notifies you that if you wish to appeal this sentence, you may do so by sending the one copy of the document to the address listed on the form no later than 42 days from today. The other copy of the form, it's the same form, 2 copies, will be returned to me, and I'll place it in the court file. And I would ask you to initial that copy. Do we need to address anything else from the people?
Briefly, Your Honor.
Sure.
Mr. Belfast from the Department of Corrections just notified me that of the petition that.
Yes, Your Honor. I noticed it was admitted for the crime victims assessment, $130. It's mandatory.
Okay, that will be included then, $130 for the crime victim. Thank you. Thank you for pointing that out. Anything else that we need to address from the defense?
Your Honor, we'll just acknowledge receipt of the notice of appellate rights and the client initial and date that and provided it back to the court. She's receiving her copy now. Nothing additional from defense.
All right, thank you very much. We are adjourned.
What do you think about that sentence? But she did a horrific crime. There was at least 17 people involved, and their lives ruined. She was pregnant, and she just driving. She didn't even know what the hell she was doing. Kids in the car, but she did look like she had remorse in her face, even with that pierced nose. I'd like to know how she was allowed to wear pierced rings in her nose, but maybe they forgot to take them out. But anyway, she has got to serve at least 30 years before even considering any kind of parole. And frankly, I don't think she's gonna get it. So she was sentenced 30 to 60 years. considering our age, that's more like a life sentence. But you never know. Somebody might feel remorse for her. Let's see how well she does in prison for the next 30 years. You know. And we have another sentencing coming up. This one. It was a robbery. And the jury found this guy guilty during the commission of a robbery. But there was a co-defendant, and the co-defendant was the one that fatally shot Martin during the robbery. So let's get back onto that one. Man, so much going on.
All right, Mr. Williams. Have you been able to read and go over the pre-sentence investigation report prepared by our adult probation about you, sir?
Yes, ma'am.
Have you been able to ask your lawyers questions if you've had them?
Yes, ma'am.
Have they explained everything to you in a way that you understand?
Yes,
If you have any questions for them throughout this proceeding, feel free to ask them, and your lawyer will let me know if you need anything or we need to stop, okay?
yes, ma'am.
Mr. Hively or Mr. Bowman, who's speaking?
On which issue, Judge, the new trial or the sentencing?
Just the pre-sentence investigation report.
Mr. Hyde, you went over the report with him? Yes.
All right, have you gone over the pre-sentence investigation report with your client?
Yes, Your Honor.
All right, do you believe that he understands what's contained in the report?
Yes, Your Honor.
And has he asked questions?
He has?
And have you answered them?
Yes.
All right, thank you. Mr. Bowman, you have a motion that you were speaking to?
Yes, Your Honor. I filed a motion for new trial within 10 days. It's basically what we already argued at trial. There's nothing new to add. I'm still taking the position that allowing the two incidents under 404B was error. The incident of the shooting of I can't think of the lady's name, Christina White on the 21st, and then the attempted robbery of Eric Cutlip on the 24th. It's still our contention that was error to allow that in, that it's not part of a common scheme or plan, didn't show intent, nothing to do with the incident that we were actually on trial for, and that it was actually just showing character or propensity. I mean, I think it wasn't a common scheme, the nature of the offenses, other than the participants, and there was a weapon involved. Other than that, there was nothing in common that would show a common scheme or plan or an MO. And again, it was just offered to show robbed people once, and they were guilty of robbing this time, and that was just to show character or propensity. But again, arguments have been raised before, but again, raising them here in motion for new trial.
All right, thank you, Mr. Bowman. Ms. Tuck, are you speaking, or Mr. Connolly?
Yes, I'm speaking. Your Honor, I would simply say that we had a McGinnis hearing. It was very detailed. It was lengthy. We put on all of the evidence that we plan to offer as 404B. We named the common scheme or plan, intent, and knowledge purposes which are allowed under 404B, and the state would feel rightfully found them to be permissible under 404B evidence. And that's how the evidence came in at trial, with a proper limiting instruction, not once but twice. So we would ask that the court deny the motion for a new trial.
All right, you're right, Mr. Bowman. All of those arguments were made at trial, I think, at the close of the state's case, and then at the end of the close of the defendant's case. And both of those times, and for all of the same reasons, I'm going to deny your motion for a new trial. You have an objection on the record. Is there anything else we need to take up? Ms. Tuck?
No, Your Honor.
Mr. Bowman and Mr. Hodges?
No.
All right. Mr. Hively, are you and your client ready for sentencing today?
Yes, Your
All right, Ms. Tuck, Mr. Kavanaugh, is the state ready for sentencing today?
Yes, Your Honor.
All right, what is the state intending to present to the court today?
Your Honor, first, the state would intend to present a little bit of argument and request for a sentence, and then 3 victim impact statements.
All right, who will we be hearing from?
We'll be hearing from Jessica Boyce, the mother of the victim, and then the victim's 2 grandmothers, Sandy Cedeno and Jill Martin.
All right, Ms. Tuck, what is the state's recommendation?
Good afternoon, Your Honor. Today, the state stands before you to request that you sentence the defendant, Barack Howard Williams, to life in the penitentiary with mercy, in accordance with the law based upon his being a juvenile, specifically West Virginia Code 611123A. The state makes this request with all the evidence that you heard at the trial in mind, including the 404B evidence indicating that the defendant and Brajon Williams Hampton were on a violent spree, looking to inflict violence to obtain property and for the simple sake of committing violence. That evidence included testimony that the defendant shot a woman by the name of Christina White in the face and attempted to shoot Eric Cullub to steal his car. The state further requests that the court recall the fact that the defendant saw Brajon Williams Hampton pointing a gun at the victim, Caden Deshawn Martin, and while acting as a lookout, decided to reach in the store and steal SpongeBob popsicles during the last moments of Mr. Martin's life. After the murder, the defendant went home and ate that ice cream, exhibiting extreme callousness and no care or value for human life, including the life of Caden Martin, who lay dead on the vape shop floor. Mr. Williams further exhibited that same callousness in the statements that he made to correctional officers and bailiffs during his trial, including, Caden, the victim, is a bitch ass N-word, including, do you like Grand Theft Auto 5? I play that shit in real life, including, do you like SpongeBob ice cream? I know where you can get some, the Go-Mart in Dunbar. And after the verdict said, I ought to smack the smile off that N-word's face, referring to the victim's father. Further, the defendant stated, when I get out of here, I'm going to piss on that N-word, referring to the victim's grave. I'm going to fill it full of piss and spit on that motherfucker. Further, despite the fact that Caden Martin's family will be deprived of their loved one forever, that Caden Martin will never experience the milestones in life that he deserved to enjoy, the defendant did not utter any apology or exhibit remorse at any point during this case or during the preparation of his pre-sentence investigation report. Your Honor, I also want to add that I think it is a manifest injustice that the defendant will be eligible for parole due to the statute after the behavior he has exhibited. If I could ask you to sentence the defendant to life without parole, I would, but I understand that this is out of the court's hands. Thank you.
Who are we hearing? Well, all right. Mr. Hively, do you wish to speak, sir?
Did you want the victim impact statements first?
If you want to present them now, you sat down, so.
Yes, I apologize.
Okay.
We would hear first from Jessica Boyce, the victim's mother.
All right.
Where would you like her?
Wherever you feel comfortable, Ms. Boyce, is where you can be. She can sit up there, she can stand, she can do whatever she wants to do.
Do you want to turn it around?
Yeah.
Just move it how you want.
Although, Ms. Boyce, you have to address me.
Yes, I am. Sorry.
Ms. Boyce, let's come back here.
She's fine.
Okay.
Go ahead.
I stand before you today just as I did before, broken, angry, and forever shattered by the loss of my son. It's been 617 days since I last saw him. Caden Deshawn Martin, forever 19. On January 30th, 2024, the defendant and his partner in crime murdered my son. Caden was my second born, my pride, my life, my purpose. That child just captivated my soul. He was full of life, love, and ambition. He had a smile that could light up the entire room, and those beautiful curls everyone remembers. He dreamed of working in finance, helping people, taking care of his family, and building a good, honest life. Because of the actions of the person sitting before you, those dreams were stolen. My son's life was taken in a senseless act of violence, planned, deliberate, and heartless. Caden was ambushed, robbed, and shot to death. Caden will never get the chance to grow into the man he was meant to be. He won't get to graduate college, have a career, get married, or have children. He won't get to come home for family dinners or sit around laughing with his siblings. We, his parents, will never see him fulfill the potential we knew he had. His siblings will never have him by their side in life. For us, the punishment is lifelong. And for what? Ice cream bars. A plan created by a 15-year-old who wanted to be in control, the instigator, the ringleader, the lookout. He orchestrated this tragedy and stood by as my child's life was taken from him. Throughout this process, every court date, every motion, every moment of this nightmare, this defendant has shown nothing but arrogance and disrespect. He smirked, he laughed, he looked back at his family and said, "I love you," while we sat there shattered, staring at an empty space where Caden should be. We don't get to tell Caden we love him. We don't get to hug him. We don't get another day, another birthday, another "I love you." His callousness did not stop in the courtroom. We heard how he bragged about Caden's death, how he talked about wanting to tear up my son's grave and piss on it. Imagine a mother hearing that someone not only took your child's life, but laughed about desecrating his final resting place. Because of that, I now have a trail camera set up at Caden's grave, something no parent should have to do, just to make sure my son can rest in peace and he is not disturbed again. To the defendant, you weren't just there, you weren't just a bystander. You thought you were tough, being tough, but let me tell you right now, you are nothing but a punk. You are weak. You will never be as good as Caden's was, not in this lifetime, not at ever. At the age of 19, my son had already become more man than you will ever be. So when you sit here and try to act tough, remember this: you are nothing compared to Caden. You two took part in stealing a life far greater than yours will ever be. And for that, I ask the court to hold you fully accountable. For us, this is lifelong, our lives forever altered. There's no moving on. Every single day we fill the hole where Caden should be. Every holiday, every birthday, every simple moment around the dinner table, we are incomplete. His dad will never hug his son again. I will never hear his voice calling me Madu. Thomas will never have his little brother by his side. Madison will never again hear her brother's laugh or lean on him for guidance. Thomas lost his brother. Home is quiet in ways that are unbearable. There is an emptiness, now a silence that screams every day, a longing that can never be satisfied. We were robbed of watching Caden grow, robbed of his future, robbed of the life we were supposed to live with him. All we can do now is to cling to the memories that we hold on to and hope that one day we will see him again. Until then, we live with the constant ache of his absence. Your Honor, this young man has showed no remorse, only manipulation, arrogance, and pride in what he has done. He thought he could play the system, delay justice, and get away with it. But what he didn't realize is that not only did he destroy one life, he destroyed an entire family. I wake up every morning and face the world that no longer makes sense. I see Caden's pictures, his clothes, his graduation cap, and I remember the boy who should still be here, tall, strong, funny, and full of plans. I relive the moment I found out he was gone every single day. The pain never goes away. It changes you. I'm torn between wanting to be here for my other children and praying to God to take me so I can see him again. It takes a piece of you that you can never get back. No sentence today can bring Caden home. No punishment can undo the hole this person blew through our lives. But I pray that the court sees this for what it is, a deliberate, calculated act that stole a young man's future and destroyed our family forever. Your Honor, I ask that you give a sentence that reflects the true magnitude of this crime, that shows that this man and what he has done to us, what he has taken my son's life. Caden deserved to live. He deserved to chase his dreams. He deserved to grow and become the man he wanted to be. Instead, we are left with a lifelong sentence without him. And lastly, I'd like to give a big FU to Bob Aaron for the lack of remorse, empathy, and simple respect you neglected to show my family while you sat beside us in the courtroom. You fidgeted with your camera, bumped my son, and placed the cameras inches from our faces while we faced the hardest thing in our lives. I begged your news station to take the images of my son with his hands up down, and you repeatedly blast them on the news. You only caring about getting the shot. I'm that glad that getting your ratings are more important than having respect and empathy. There's a special place in hell for you also, sir. Thank you, Your Honor.
Thank you.
Next, we would hear from the victim's grandmother, Sandy Cedeno.
Please spell her last name.
CEDENO.
Okay.
Caden Deshawn Martin was born September 13, 2004, and was senselessly murdered on January 30th, 2024. I received a phone call from my daughter screaming that my grandson, Caden Deshawn Martin, had been murdered when the smoke shop he was working at was robbed. I will never forget her screams or mine. I hear them over and over again every single day. Caden was 19 and working to put himself through college. Caden was so smart, kind, funny, and loving. He had a way of making you laugh when you didn't want to. He loved his family and friends, and he would do anything for anyone. Everyone that met him loved him, and if you would talk to any of his customers at that shop, they would tell you how kind he was. Caden had never been in trouble, went to church, and led his church youth group. He was there for his young cousins to help guide them. He also was there for his brother and sister, for all of us. Caden had the most beautiful green eyes, curly hair, and a smile that would light up a room. Caden was going to make something of himself. Caden touched so many people throughout his life. Barack Williams and his accomplice took our boy away from us for the thrill they thought they would find. They had been on a 9-day crime spree that consisted of robbing and shooting a woman and trying to rob and shoot another man. They both had been in trouble before and didn't learn from those things, so they thought they could get away with this. They were out to really hurt someone, and that ended up being my grandson. They could have just taken their merchandise and laughed, but they wanted to harm him, and they did. This was planned, as were the other incidents. Our lives now have a hole in it, a void we will never be able to fill. We will never get to see Caden smile, hear his voice, or feel his hugs again. Caden will never get to see another sunset, sunrise, hear the rain fall, the thunder boom, feel the wind on his face, have a child or a wife. We have lost our ray of sunshine, our joy. Every morning I wake up, my first thought is of Caden, and the same when I go to bed. I can't concentrate at work. I have no joy in my life. I feel empty inside. All I can do now is live with a constant silent scream inside of me because the emotional pain and grief is too much to handle. Caden's presence was a gift, and his absence leaves a huge hole in our hearts that can never be filled. He was loved beyond words by so many and opened his heart to everyone he encountered. My heart is broken for my family, for the future that Caden will never have, for the family he won't be able to create. This has been devastating to try and accept. It still doesn't feel real, and I don't think it ever will. Caden was everything Barack and his accomplice could never, ever be, which is loved, accepted, vibrant, accomplished, brave, and just so wonderful. And they knew that. They had been in the shop numerous times and spoke with Caden, so they knew what a good person he was, and they couldn't handle it. Caden wasn't offered a plea deal. He wasn't offered a trial wasn't offered a chance to defend himself. But these two punks are able to get mercy. They didn't show Caden any. Our boy will never get a chance to come home, but they will. Because of Barack Obama, Williams and his accomplice, a beautiful, compassionate person was taken from this world for no reason. They didn't just take his life. They took his light that carried into every room, and they destroyed a family. Not only have I lost a grandson, but I have lost my daughter. She will never be the same. None of us will. They stole my beautiful grandson's life, and they stole the rest of mine. I miss Caden with every beat of my broken heart. Our family will never get closure or justice. I think the words closure and justice are crack. And I say that because I don't know how you can have a loved one taken from you in such a violent manner that these two boys did, for no reason at all, and ever be able to wrap your brain around how and why that happened. I have lost my faith. I have lost myself. My life is all over the place like what I just said to you, okay? It's just every day. I cry every day. I talk to a grave. I clutch a necklace with Caden's ashes in it. I hold a photo to my chest. I hug a bear made from Caden's shirt. This is all I have left of my grandson. Those and memories, and that just isn't right. He should be here. These boys knew what they were doing. He has no remorse. He comes in here laughing and smiling and joking. The things we've heard he said to the deputies about peeing on my grandson's grave and tearing it up, he deserves no mercy. He's going to come out and do the same thing again and again. We don't have a chance. Caden doesn't get a chance in 15 years like they do. I know that you have no say in that. I totally understand. But it's wrong because we have a life without our boy while his family gets to see theirs, talk to him, call him, visit him. One day hug him. One day sit down at a dinner table with him, watch TV. We never have that. We are all empty and broken. Not only my daughter and Caden's father and Caden's brother and sister, me, my husband, my other children have lost their nephew. My grandchildren have lost their cousin. My sisters, brothers have lost their great-nephew. We have nothing anymore. Caden was so wonderful. If you met him, you would know that. He was so funny. I'll never get to hear him look at me when I say something stupid and say, nah, Nana, nah. That's what I hear in my head every single day. I'm at work, and I'm sitting there at the office with the doctor I work for, and he's talking to the patients, and all I see is Caden's face, and I hear his voice. We'll never be the same. This person here, I'm not even sure if I can call him a person. He deserves to rot in hell, and I hope I hope you do. God's got you. God's got you. Thank you, Your Honor. I'm sorry.
That's all right. Thank you, Ms. Is it Cedino?
Sedan, yes.
Sedan. Lastly, we will be hearing from Joe Martin, Caden Martin's other grandmother.
Good afternoon. Take your time. This is your time to talk. No rushing.
My name is Jill Martin. I'm Caden Martin's paternal grandmother. Barack Howard Williams showed no remorse during his trial. He didn't even look at the video of Caden being robbed and murdered. He walked in on days smiling. He was on trial for felony murder and smiled and smirked. Caden was an amazing human being. He did not deserve to be gunned down. It is sickening to think of this teenager stealing ice cream while Caden was scared for his life. Then to go home and eat the ice cream, knowing you left someone on the floor to die. He tried to play victim as his defense. No one forced him to do any of his actions that night. At any time during these senseless actions, he could have stopped it. The victims in this case is our beloved Caden, as well as the many people who loved Caden and would have given their lives to save him. Caden gave everything asked of him. So the motive was not the vapes, the money, or the ice cream. They got all of those things. The motive was to kill. The lives of those left behind who loved Caden, have been changed for the rest of their lives. I will never get to see my grandson smile or hug him again. This teenager does not deserve any type of mercy. Caden was shown no mercy that night. Caden was so special, and we shed tears every day over his life being taken so soon. He made a positive impact on those around him. He always told me, "I love you, Maine." He was brilliant, ambitious, caring, kind, and loving. He was the light of our family. No sentence on this earth will ever bring enough justice, but the maximum allowed by state law is all we can ask for. Thank you.
Thank you, ma'am.
Your Honor, the last remark that I would make is to note that the Victims' Compensation Fund paid $5,940.95 for funeral benefits on behalf of the victim, and we would be asking for restitution paid to the Victims' Compensation Fund.
All right, thank you. Mr. Hart?
Yes, thank you, Your Honor. Your Honor, I'll be brief, and I'll just put on the record for Mr. Williams, a conversation we had at Gene Spadero. I told him I believe the human beings are better than the worst thing they've ever done in their life. We all stain and tear the fabric of our life. But through grace, time, and personal effort, you can clean that and mend that. So he has two important dates. October 31st, 2011, he'll be 18 and be brought back before the court. And
2000 what, I'm sorry?
I think it's 2011, he'll be 18. Sometime after that.
No, not 2011.
You're going back.
2000, I'm sorry, 2027. Okay. He'll be 18 and by code, he'll be brought. You know, I would probably, being honest, that the reconstruction and the reconfiguration of his life to make himself better than what jury's found that he's did, that probably won't be enough time. But February 1st of 2039, he'll be brought from wherever he's at, and he'll sit down with the parole board, and they'll sit out and look at the criteria for parole, and that's where he'll need to show what he's done to make this, and show his efforts to make this, and show what he's done to improve himself in life. He needs to get his education, his GED. He's 14 years old when this happened. He'll be almost close to 30. During that time period, he can get as much education as he can. He can read everything they have. I believe a man is what he reads. He can reflect on the time. So sometimes you got to be your freedom taken away. And that he can reflect. He's got a long road to make himself a better person. I think we all have that in our ability to leave this place better than when we came into it. And he'll be a young man. And if he takes the time and through self-improvement, grace, and everything, staying out of trouble, he can turn his life around and make amends for what the jury has found. Right? So by law, the statute's already, the penalty's already there. And so he knows what he needs to do, and it's up to him now to decide if he's going to meet that effort that's required to make yourself a better person than you were at 14, or at 18, or at 30. You'll always, every day, be the best version of yourself. Thank you.
Does your client wish to speak, Mr. Hunt?
You want to say?
Yes, sir.
You'd like to speak now?
All right. Mr. Williams,
Yes, ma'am.
you may speak.
To the Mormons, I am so sorry for what happened to your son, and I know there is nothing in my power that I can do to bring him back, but I am with y'all and justice needs to be served. But justice was served the day BJ took that plea deal to the horrible act of murder and robbery. I took no part in that entire heartless act that took place that night. Caden Martin, your son, was tragically killed. The night Caden, and taking away from his family, loved ones, and friends. Yes, I was there unmedicated at the time the heartless took place. We were supposed to be getting some Rellos so I could roll up some weed, and we could smoke as a blunt. I never knew any of this was going to happen, or else I would have never came to the smoke shop with him, especially after doing 18 months and being out for only 2. I was cool with Caden. I get saying that probably don't mean nothing to y'all because BJ is family to y'all, but I say in my heart, I'm so sorry for what happened to poor, defenseless, young, kind, caring, loving man. No matter what, locked up or free, I will always make sure his story is told. Long live Caden Martin.
Is that it?
And I apologize to his family. Yes, ma'am.
Thank you, sir. You may sit down. Is there anything further, Ms.?
I'm only surprised that the defendant chose to apologize now, but no, Your Honor.
Mr. Hines?
No, Your Honor.
Well, I didn't take that as an apology, actually, Mr. Williams. What I took that for was exactly what that was meant for you to abdicate yourself of responsibility. That was possibly not the worst thing I've ever heard a defendant say, but it was close. You sat there in front of the victim's family after they told you over and over again how much they lost and told them you didn't have responsibility for it. But the jury disagreed and convicted you, which was the right decision. First, I want to acknowledge the family of Caden Martin, Jill, Sandy, and Jessica. You have all shown a tremendous amount of restraint. You were here through the whole trial. That could not have been easy. You all were strong, and you all just sat through what the defendant said. So for that, you are to be respected and appreciated. But Sandy, you are right. There is nothing that I can do that will undo the suffering that you all have endured and will continue to endure for as long as you're alive. There's no sentence that can fix this. There's nothing I can do to bring him back. But I do believe that God is with you, Sandy. You said you lost your faith. I would say the same thing to everyone else. Caden's dad, family, everyone that's here. It means a lot that you're here for him. And this whole case is a testimony to just how senseless and awful gun violence is. This court has carefully considered all of the evidence presented at trial, the pre-sentence report, the defendant's psychological evaluation, and the factors contained in 611113 of West Virginia Code, which addresses the factors the court should consider when sentencing juveniles. First, everyone here has acknowledged this, that 611113 of the West Virginia Code states that a sentence of life without the possibility of parole may not be imposed on a juvenile. Further, upon the age of 18, this defendant has the right to come back before this court to be resentenced. According to Mr. Hively, that's sometime in 2027, correct? Not long from now. At that time, Jessica, Sandy, and Jill, and all of you here will have to go through the same thing over again. For that, I apologize. I don't make the law. But at that time, the court will consider all of this again. The court will consider anything that you had to say, Mr. Williams, when you turn 18. The court will consider any progress or lack of progress that you have made between now and the time that you turn 18, when you come back to be resentenced. But today, I have to impose a sentence for a profoundly terrible and serious crime, the taking of another human life. And from when the evidence is presented at the trial, the taking of a life after Mr. Martin gave you all everything you wanted. A crime for which you, Mr. Williams, although you were young, had the capacity to know was wrong. You knew it was wrong to rob a store. You knew it was wrong for your co-defendant to go in there with a gun. You knew it was wrong to act as a lookout. You knew it was wrong to steal. You knew it was wrong to go back and eat it. You knew it was wrong, the whole thing, the whole time it went on. But you don't have any appreciation for that. You got convicted of it and immediately turned around and said that what you were looking forward to when you were released was desecrating the victim's grave. Those are monstrous words. It's a monstrous mindset. And if you do not take advantage of the rehabilitation that is offered to you, sir, you will have a long life of incarceration, I'm sure of it. Along with those statements, your behavior during trial, the evidence adduced at trial, and what you said here today, Mr. Williams, you make my job easy. I do not have any choice but to impose the maximum that the law allows on you, sir, which is life in the penitentiary of the state of West Virginia without the possibility of parole, with the possibility of parole after 15 years. I truly wish I could give you more. It is the court's job to hold you accountable for the life that you and your co-defendant stole from Caden Martin and his family. It is also the court's job to protect the public from you. And it is the court's job to put you in a place where you can take advantage of the opportunity for rehabilitation. The law recognizes that young offenders have the capacity to change. Mr. Hively talked about that. And I sincerely hope you do, because what you presented today is a depraved, malicious, violent, unremorseful young person. A person from whom the public must be protected. Caden Martin's family will have to endure a lifetime. If you are not resentenced, if you are sentenced to the same thing at the age of 18, when you come up for parole, they will have to go through it again and again and again. The true victims are sitting over there, sir, and it is certainly not you. Is there anything further, Ms. Tuck?
No, Your Honor.
Mr. Hively?
Your Honor, I just asked the court to inform Mr. Williams about his right to appeal. We talked about it a couple times, and whether he wanted us to continue or if he wanted new counsel. But we discussed that. He's aware of the time period.
I don't think that does the law require me to do something specific?
The different circuits just instruct the appeal, the time period to file the notice.
Well, you've informed him of that?
Yes, yes.
All right, Mr. Williams, you have the right to appeal your conviction. Your attorneys have explained that to you. You could request new lawyers if you want to. If you could do that through your lawyers, that would be fine with me. However you want to transmit that information. Mr. Hadley, you can let me know how he wants to proceed. I have nothing further. Thank you all. Court is adjourned.
Thank you, Your Honor.
All right.
I was gonna give them all their tickets.
And there you have it, guys. 2 sentencing. Very hard. I mean, the first one, she's gone away for life, really, 30 to 60 years. And all because she drank and ran over all those people. And this punk, laughing, says he's gonna piss on the grave of that poor deceased kid. Parents in the room, you know, they made their statements. Listen, he didn't have no remorse. That's how he is, gangster style. He didn't care. He may have not been the one that pulled the trigger, but he was there in the act of a robbery that ended somebody's life. A 19-year-old Camden who did nothing to nobody, was earning an honest day wage from working. And these punks want to come and rob you. He didn't care. He's only caring that he got caught. And what the hell is this? Just because he's 15 years old, he only can get a certain sentence because of his age? What the hell? We're putting these 12-year-olds in prison for life. What's he so special? He's got to come back when he's 18 to be resentenced? He only can get 15 years? Well, Camden got a life sentence in the grave, and the mother and grandmother got a life sentence. I don't understand this. He should have got at least 30 years, put him behind bars, because once he's in jail, I don't know, he might change. You never know. You never know. Might need a miracle. But you start getting involved with people in prison, he could come out worse. He could come out a worse man than he went in. So we'll have to see how that goes. So he's got to come back in a couple of years when he turns 18. I've never heard such crap. Oh, you know, he's under 18. I can't sentence him anymore by the law. Well, change that law. Change it now. In the name of Camden. Change it. Because that's damn crazy. And he thinks, oh, well, I'm getting out. And he knew it. I'm getting out. They only can do so much to me. You get out, maybe he'll get out on good behavior. Who knows in that state? Get out on, hey, I've served 85% of my sentence. I'll get out. There's always a worse criminal than me. It's It's ridiculous. You both went to rob the store, no matter what. Your intentions were to do harm, and you did. Both of you should have got a life sentence. But anyway, guys, that bites another dust, you know what I mean? Another 2 cases over. And don't forget, guys, we have another Wisconsin trial coming up. Logan, he's the one when he was 16, 15 or something. He was quite young. 4 years ago, maybe coming up 5, but it was definitely 4 years ago, that his girlfriend, who was only like 13 or 14 at the time, gave birth at the home. When her parents went there, she calls him, or he was there, but I think she called him over and said, "We can't keep this baby, brand new baby, not even dressed, not even the cord cut." Took the baby, threw it in a backpack in the freezing cold. I think it was January, but it was freezing cold, snowstorm. Went home, got a pow pow, walked the streets to the woods in the freezing cold while that baby was still alive in the freezing cold in a backpack. And 2 pow pows to her head, that little poor little baby's head. I mean, we know how big a baby's head is. 2. Now, he's been going through the juvenile system here in Wisconsin. Does he get tried as an adult? He shouldn't. Excuse me. He, what he did was his brain wasn't working properly. Do you know what I mean? Yeah, his brain was working properly. I mean, who didn't know that that girl was pregnant? They must have known. Parents must have known. And he did what he did anyway. And he is now finally going to trial. And they wanted to move this trial. Moved it. And they wanted to move it out of state. Now, I read something that they have moved it to a different county. But that county is in Minnesota, not far from the border of Wisconsin, Minneapolis. I mean, what's going on here? So I got to clear that up because I did read that. And to get a case out of a state, there takes some special circumstances. But what I did read is that his case has to stay within the Wisconsin state laws. But so since he was first in court till now, he's grown up a lot. He's heavier. He's not so innocent looking, okay? Because he's grown up a little bit. And he's put on weight because, you do. Because you keep eating those Twinkies and no exercise. Now, he's probably completed his education while he's been behind bars awaiting trial. So there's been a lot of problems with this case, a lot. Now, I don't know why there's been so much problems with this case because we've had a lot of juveniles move to adult court for less, okay? For less. Just think of, it's still a crime what they did, but I mean, their victims didn't die, like the Slender Men, like those two. There was a victim 19 times, you know, all over her body, and she lived 19 all over her body and walked out of that park here in Waukesha. Them kids were 12 at the time, sentenced to 25 years and 40 years. But they're out now. But the point, that was their sentence. And still is. If they make a wrong move. So when you think about cases like that and other cases, you think, what the hell is going on in this county? He's 15. Somebody died in a robbery. And that's all you're going to give him? 15 years because of the law? You know, got to change the laws, guys. Wherever that county, that state, change the law, because we don't want that happening again. And we don't want those criminals thinking they're going to get away with it because they're a juvenile. Because that's exactly how he thought. I'll be home and laughing. Think it was funny. See, that's a gangster in the making, isn't it? He didn't have true remorse. He doesn't have true remorse. It's something that he had to say, and it's something that he had to do. Oh, did you hear his statement? He expressed remorse during the sentencing, saying he was so sorry for what happened to a poor, innocent young kid, caring, loving man. Yeah? That's different to what he was saying before when he wants to piss on his grave and all those other kind of things. I'll be out. See ya. Yeah. See, they act one way in court. Once they're out of that courtroom, true colors. They show their true colors. When they're in the jail, when they're on the telephone to family. You know, we've heard a lot of recordings from different defendants. Yeah. They have no remorse. Oh my God. And I hope that Michaela, she's one of them. Her and her mother on the telephone. You know, for instance, the one that drove her boyfriend and his friend into a brick wall. Yeah, she thought she was getting out too. All she had to do was just cry a little in court. But over the phone in the jail, she was a different person. If somebody's got true remorse, you can see it in court, true remorse. You can see it on their faces, and they mean it. You know, as long as we don't get the recordings from jail saying otherwise, you know, there are people that true remorse, like the first sentencing that we watched in this video. She truly has remorse. But the thing is, she drank and drove, didn't know. There was people in front of her. She didn't know how fast she was going, and she was pregnant. So Yeah, they said, oh, got a drinking problem. Well, we don't care about your drinking problem. You should have got some help for your drinking problem. Because if you don't, this could happen. And it did. Maybe you should have got in the car and drove. If you wanted to drink, you shouldn't have got in the car and drove. You should have walked. Sobered up. So anyway, guys, thank you for stopping by. Don't forget to like, subscribe if you haven't, and share my channel out. Share. Sharing is caring. It's all free, guys. You don't have to pay. It's all free to like, share, and subscribe. It's memberships and all that you pay for. So I appreciate you all. And if you want to see more of these two little partners in crime, Crime Wine Murphy, the Shih Tzu, and his partner, Princess. Look at their cute faces. If you'd like to see more of them in action, watch my shorts. And see you in the next one.